lords. Just bear in mind one fact, not that prior to the enforcement of this act in 2009 and the issuance of the notification under Section 23, the Academic Authority on 23rd August 10, we had our own set of rules, Lord, and an examination also for recruiting the teachers. So everybody has, and the qualifications which are prescribed under 2000 and under Section 23(1 are substantially similar as in our rules, Lord, prior to 2009. After 2010 in Madhya Pradesh, everybody has a TET. Question is of Lord extending this to a point of time prior to the emergence of this act itself, Lord. So I am only, my lord, attempting to draw your lordship's attention to the extension of retrospectivity prior to this emergence of this act, my lord, and the notification of 23rd August. Now please see the second proviso.
Yes.
Provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualifications as laid down under subsection 1. Please mark this expression, as laid down in subsection 1. Now this notification, this takes us back to 23(1). And 23(1), the notification has come on 23rd August 2010. So therefore, it is only, Lord, the retrospectivity can be only to the point, Lord, when the qualification was prescribed under 2010. It cannot, Lord, extend to 1998 and 1995, Lord, when the teachers were recruited. So if after 2010, there is somebody lacking TET or other qualification, I'm assuming that TET is also a qualification. That's what your lordships have observed. I'm not for the moment questioning, Lord, as far as I'm concerned. So assuming TET is there.
Well, thank you.
The TET came in 2010. Before that, we were having our own examinations, Lord, and there was no TET.
Where is my... I'm sorry.
So therefore...
Let's tell you what I have noted from your petition, State of Madhya Pradesh.
Yes, ma'am.
Education is a state subject. There existed state law prior to the coming to force of the RTE Act. RTE Act does not automatically override the state law. This is one point. Court had no occasion to examine the interplay of RTE Act with state laws. Interpretation of court does not align with the statute and rules thereunder, which never intended to apply TET to in-service teachers. SOR of RTE 2017 highlights that infrastructure was sought to strengthen the training for the untrained teachers. Intention behind including proviso can never be to apply to in-service teachers. Over 70,000 teachers.
Your lordships have rightly noted the submissions from them, but I am not pressing, I am not saying, my lord, that after 2009 our state act will continue. I am not saying that. I am not saying so. Please.
For those teachers who have been in service for more than 2 decades, 3 decades, we have provided a relaxation for them depending upon their age. But those who are 55 plus, they need not.
But
we have exercised our one.
With great deference, my lord, second proviso does not, my lord, require, extend, my lord, its application to those recruited earlier.
What do you mean by 31st March 2015, sir?
My lord, that has to be restricted to the notification because it says as provided in subsection 1.
Every teacher notification under 23(1) prescribes the qualifications which every teacher has to possess. Second proviso extends the time period that if you have not acquired the qualification within first 5 years, we are extending it for another 2 years. Otherwise, this proviso does not bear any meaning.
My lord, if it is not extended earlier to this point of time, 23rd August 10, it will be manifestly arbitrary, my lord.
We'll consider.
Lord, kindly just examine, my lord, if today we are required to pass the Bar Council examination after 30 years.
This argument was raised, Mr. Dwivedi. This argument was raised before the bench. We had the occasion to consider.
This act does not purport to repeal our state acts and rules retrospectively.
We'll consider. We are not saying we will not consider. We'll consider.
No, well, it's my...
Dr. Singhvi, you are for whom?
I am for this entire batch of 2001, 2002, 2003.
No, in the
individuals.
Individual. What is the name of your
301.3.
30.
300.
301.30.
3.1. 301.30.
Can you give the name of the party?
Amit Kumar Singh. That is, will you stop a commentary? 301.30. Amit Kumar Singh. I only have 4 dates to give, Your Lordship. Only
That's
4.
very well. Amit Kumar Singh.
Yes. Your Lordship, keep this compilation on the side. My 4 dates are this, fellas. There was, just 4 dates, Your Lordship will note. There were 3rd September 01 regulations.
3rd September?
01. That is almost 25 years ago.
Yes.
In this compilation at page 23 are the extant regulations on that date. I was clearly qualified under them. Please give it to my lords. Page 23. Only 4 dates and 4 documents. I won't take long. And lordship need not go into the merits of it. Just glance at it as to whether this is 2001 September. That table, Malas. Don't go into the nitty-gritty of it, but they clearly qualified under that. This is my compilation.
You said 3rd September 2001. This is not there in your compilation? Second, very well. 17 to 24.
Yes. It's the relevant parts only I'm showing Malas. 22 at 23.
22 at 23.
Number 2.
Yes.
Well, number 2, of course, in between now comes on 1st April 2010, the Act, the RTE Act. That date is 1/4/2010.
Yes.
On 23rd of August 2010,
Yes.
a notification is issued requiring the TET. Right, fellas?
Yes.
But it has a significant exemption because they know that there are 50,000 plus teachers like this in the rural areas who don't have this qualification, who have the other one. That is relevant at 31 of this compilation.
30?
Yeah, it starts at 29. Joshua may ignore the rest.
31.
At 31, that exemption is consciously given to protect people like me. Teachers appointed before the date of this notification. Of course, I'm in the hoary past. Even immediately before this is 2010. The following categories of teachers appointed from classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified. Then, Malads, a particular category is A. If appointed on or after, then there's a proviso. We are not concerned with that. The third is that this exemption at page 31 is reaffirmed and reiterated at 34. That's my third point. 29th July 2011, Lordship has reached now. That is 1 year after the RTA Act.
Yes.
Justice Banmohan has got 34. On this date, the relevant part of this is at 34 starting, 35 is the relevant part.
Yes.
Teachers, 5A. Teachers appointed after the date of this notification in certain cases, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointment may be made in accordance with the NCTE regulations of 2001, which I showed to your lordships. Conscious exemption because they didn't want to penalize people who had done to the best of their ability in the hoary past something, which was then the valid thing. Then, Malas, comes the amendment to the Act as the fourth document or the fourth point. That is at 38. 38. That is the NCTE Act amended 38 at 47 is the amendment of 12 capital A. 12 capital A. This is, Malas, WEF 16/2012. WEF 16/2012. Lordship, we got 12A. Justice Banmohan has got 12A. At 47, Malas, 38 at 47. 38 at 47.
Yes.
Now, I am interested in the proviso, but your Lordship may read the whole. Power of the Council to determine minimum standards of education. For the purpose of maintaining standards of education, the Council may by regulations determine the qualification of persons who will be recruited as teachers in any pre-primary, primary, upper primary, secondary, senior so-and-so, intermediate, by whatever name called, run, aided or recognized by central government. Provided, if your Lordship doesn't mind, provided that nothing in this section shall adversely affect the continuance of any person recruited in any pre-primary, primary, upper primary, senior secondary, intermediate, or the colleges under any rule made by the central government, state government, local authority, other authority, immediately before the commencement of the so-and-so Amendment Act of 2011, solely on the ground of non-fulfillment of such qualification as may be specified. Further, the minimum qualification referred to, etc. These are conscious statutory or delegated legislation exceptions.
No, read further, provided further.
Yes, provided further that the minimum qualification teacher referred to of the first proviso shall be acquired within the period specified in this act or under the right to free act, etc. Correct?
You will have to acquire it.
No, Malas, now, these are people who have been there, Malas, 50 years.
Maybe the statutory provision is that you have to acquire it. See, the problem that is arising over here, Dr. Singhvi, is precisely this.
But before this amendment.
This proviso says that even the teachers who've been appointed prior in date
Yes.
will have to get this additional
That may
qualification.
not be the right interpretation. May I
No,
explain why?
see, we have looked at it and my brother has explained it in detail.
So therefore,
We
I
are
am trying
looking at the act from the perspective of the child. We are saying higher education qualifications of the teachers is required because we must get the best teachers.
So, Malas,
See, unless until you get good quality education, how will the child improve?
so my answer is this.
You have to have good quality
I am
teachers.
requesting my lords to interpret it as a very strong alternative interpretation. This one which your lordship asked me to read is a proviso which will apply to those appointed after the act but before the amendment.
No, that is not true.
Before the amendment. No, but because the amendment says so.
We'll
That's the
consider.
contention.
We'll
Please see.
consider.
This is brought by an amendment.
We'll-
It is
we'll
not brought by the act.
We'll consider. We'll
But can I have
Fully obliged.
5 minutes?
Yes.
5 minutes.
To add what Dr. Singhvi said, but after.
Just 5 minutes. Lord, kindly,
Who are you for?
I am for Milord. Point 57, Jyoti Singh. So, Milord, if your Lordship had those 4 dates again, without reference to papers.
Jyoti Singh.
Yes. So, Milord, the first relevant date is 1/4/2010. That's the commencement of the Act, Milord. The Act of 2009 came into effect on 1/4/10. So prior to 2010, there was no real problem. On 1/4/2010, my lord, there was no TET requirement. The requirement came, my lord, on 23rd August 2010. And then, my lord, is the last date, which is, I think, 23rd of August 2017, when the second proviso, my lord, was added, which takes us back to being in position in 2015. That's, my lord, the conspectus. That's the conspectus. Now, my lord, if your lordship will be pleased to see section 23 and the notification of August 2010. Just see 23 once again, my lord.
Yes.
Any persons possessing minimum qualification is laid down by an authority authorized by the government by notification shall be eligible for appointment. As so, this is, my lord, prospective. Those who are going to be appointed. Then the lordship sees, my lord, the first proviso. Provided a teacher who at the commencement of this act, commencement of the act is 1/4. The commencement is not August. Whoever, my lord, at the commencement of the act, that is a person, my lord, who's already there. So there are two different, my lord, groups. Under 23(1), those who are going to be appointed henceforth, and this proviso is those who are already, my lord, in place. Those who are, I'm reading, my lord, that way, those who are teachers who are at the commencement of this act, that is, my lord, on 1/4, do not possess minimum qualifications. Under 1 shall acquire. The submission is, my lord, that people like us who were there as on 1/4, we possess the qualification under 23(1) because there was no August. There was no TET. So to say, my lord, that we will be given a grace is wrong because the issue arose in August. So on first principles, those who were in place by virtue of, my lord, this proviso would only be required to fulfill 23(1), and 23(1) on 1/4/10 did not have TET. That's one part. Now, my lord, your lordship may have a look at the notification of August. My lord, your lordship might have it in Mr. Singhvi's compilation.
Mr. Rothi has not looked at second proviso. The whole case is on second proviso, not the first proviso.
Second proviso comes in 17. I'll come to that, my lord. Please bear with me. First point I'm making is, this proviso does not apply to me.
Not on the first.
I am developing the first, then I will go to the notification, then I'll go. Obviously, my lord, if you just read the second, then obviously if you look at it that way, then everything is gone over. What I'm trying to say is, my lord, I was not requiring any grace as on 1/4/2010. In short, I didn't require a grace. I was very much in place with the requirement of relevant qualifications as on, my lord, 1st April 2010, the first submission, without grace. Now, my lord,
1st April 2010,
my lord,
the qualifications had not been prescribed.
correct,
Correct?
correct,
It came into existence
August,
on 23rd August 2010.
right,
So therefore, what the first proviso ordains is this. If you are a teacher on 1st April 2010,
yeah,
you are given 5 years time to acquire the qualification. From which date 5 years will count? It cannot count from 1st of April 2010 because the qualifications had not been prescribed.
correct,
It will count from the date the qualification is prescribed. That is 23rd August 2010. You have a window of 5 years. 2015, if you don't qualify,
I understand, lord.
2000,
Yes,
you see, that is why it is again made
my lord,
effective with retrospective effect.
I submit,
You are given 2 years time.
I
5 plus 2.
I am only saying, my lord,
In
that
fact,
the first proviso talks about commencement of the act.
Mr. Rothi, my brother has been very benevolent in giving you some extra time. I was telling him, let the statute operate as it is. And we had a long
All
discussion on
right,
this.
so one more argument. One more argument.
He's been very, very benevolent.
Now, one more argument, my lord, which is based on what your lordships gave me in the order. Kindly turn to the order. Let me read the order first, my lord, and then make the submission. Kindly turn to para 168. 168 of your lordship's judgment.
Paragraph 168.
Yes. NCT 168. The argument is this, my lord. In other words, that the requirement of TET is only for those who were appointed post August 2010. In that light, we were exempt in 2010. My lords will remember, we were exempt under 2010. Can I just show that and then read 168? 168 is completely in my favor. May I read 160?
Read it, but just answer one question.
Yeah.
TET requirement gets incorporated on 1st August 2010.
Sorry?
TET requirement gets incorporated.
Yes,
on 1st
absolutely right.
So there can be no recruitment after 1st August 2010.
Without that.
If your submission is accepted, then the second proviso will have no relevance. It should never have been there.
So what I am telling,
Therefore, Mr. Rothi, you're missing the point. The point is of what is the significance of second
my
proviso.
lord, second proviso does not specifically say that the exemption granted in 2010 is gone.
Who are in position on 31st March
Of course.
2015, they will have to acquire it.
Mr. Rothi,
So by-
understand, the teachers have to upgrade their skills.
Achha,
They
just-
have the best standards for the
I-
examine it from the
I've
student's
seen,
point.
no, I've seen,
Let them have the
which,
best
I am
teachers.
seeing which way the wind is blowing. So I won't put it another way. I just want to read 168.
Okay.
This is not in my favor. That's why I'm reading it. Para 168. NCT's notification reinforces this requirement by stating that teachers working in unaided schools or those in position as on 31st March 15, like me, my lord,
That is the relevant.
must qualify TET. Now, next para is important. The language of both the RT and the notification leaves no room for ambiguity that even those who were appointed prior to RT, like me, if not qualified, must not be TET against me within the grace. Now, look at the next line. Only those appointed prior to so and so in accordance with those applicable rules or covered by specific exemptions. This is in the notification of 2010 are exempt.
Exempted, but thereafter 17 does not grant you that exemption.
You know, if you are
This is the difficulty.
you are exempted and then you take what do you give
Well,
by the left
yes,
hand, you take it away by the right.
Yes.
What happened?
Let's just add one line.
Yes, yes.
You had your fill.
Mr. Gupta, you were there?
You had your fill in the previous round. How many days we heard you?
May I remind you a lot?
5 days.
He should not be stopped, you know.
No, not at all.
No,
But
Milord.
Mr. Gupta will hear you because there are other people.
If your lordship is going by seniority, my lord, then Mr. Bikash Bhattacharya should be heard first.
Then-
Me, then my lord.
Then- Very well. We'll go by seniority.
I will myself confined specific to the question of Milord 23 proviso, second proviso.
Second proviso, yes.
May I read it, Milord?
Mr. Bhattacharya for whom?
1931 and 39 and 2325.
Now just give the
19
first party's name.
Bidhan Kumar Mondal.
Bidhan Mondal.
আর আমাদের পাঁচ পাঠান।
Bidhan Kumar Mondal. Right.
and শ্যামলী হালদার
And Shamali Haldar.
0.31 শ্যামলী হালদার আর
Rashmi.
সোনালী চৌধুরী
Is-
and foreign three names
Bidhan Kumar Mondal. These are separate review petitions.
yes mother three
Shamali and the last one,
সোনালী চৌধুরী
Sonali. Very well. Yes, Mr. Bhattacharya.
So, Milord, section 23, Milord, should be read in its entirety.
Right.
Yes. Now, Milord, the first is, Milord, the Act desires that there should be a prescribed qualification by competent authority. And then say that any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as teacher. This is the prospective in operation. Now, second is where state does not have any adequate infrastructure, they will be given 5 years time. Then let's second, provided, the first proviso. A teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. And then second proviso, provided further, this is important, Lord, we are governed by this, that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right to Children Education Act. Now, our appointment was, Milord, at a point of time when, Milord, the academic qualification was, Milord, determined by the NCTE. And my Lord will kindly turn to, Milord, the
রেগুলেশন
in the matter of, Milord, Anjuman Bidhan. Milord, kindly turn to, Milord, page 155.
What is that? What is that 155?
155 is the NCTE, Milord, regulation, notification, dated 23rd of August.
23rd August 2010.
Yes.
Very well. Yes.
Now, Milord, here, my Lord, we'll find, Milord, details are given, then kindly come to, Milord, at page 157.
You just refer to the regulation number.
Yes.
Because we are looking at this compilation.
Milord, regulation 4 of,
Regulation 4.
yes, of 23rd August 2010 regulation.
Regulation 4.
Notifications.
2010 notification
Teacher appointed before the date of this notification.
Yes,
Is that the marginal note?
yes. Teacher appointed before the date of this
This
notification.
notification. Yes.
The following categories of teachers appointed to class 1 to 8 prior to date of this notification need not acquire the minimum qualifications specified in para 1 above.
Right.
A teacher appointed on or after 3rd of September 2001, that is the date on which NCT determination so regulation 2001 as amended from time to time came into force in accordance with the regulation. And Milord, we are all governed by these. Then Milord, TET was not at all, Milord, a qualification necessary for the purpose of recruitment teacher, but we had, Milord, different training, not TET.
রেগুলেশন
Then Milord, kindly turn to, provided that a teacher of class 1 to 5 possessing B.Ed qualification or a teacher possessing B.Ed special, my lord, this is not relevant.
2001 regulation.
Dada, chuk korbe. Then my lord will kindly take the trouble to turn to page 163.
Good to hear Bengali in court again.
Have a great
That is the inherent resource. Kindly turn to page 163. That will also clarify the position.
This is what?
29th of July.
29 July 2011.
Yes.
Yes, 29 July 2011.
Yes.
Which clause?
Para 5.
Kindly turn to clause 5. Rather, para 5.
July 2011. Yes, para 5.
For para 5 of the principal notification, the following shall be substituted, namely, teacher appointed after the date of this notification in certain cases where an appropriate government or local authority or school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification. Such appointments may be made in accordance with the NCT Determination Regulation 2001. Therefore, it's very clear that the NCT had the basic conception in the mind that prior to 2001, the TET qualification was not available, it's not necessary. Then let B, the minimum qualification norms referred to in this notification apply to teachers of language, so and so for different languages. Now, basic thing, Milord, that even in 2011, the NCT found that 2001 regulation appointments did not come within the scope of TET. That is one important thing.
2001
And
regulation.
if your lordship kindly comes, 2001 regulation, lordship will be pleased to find.
Page number 142.
137.
Let turn to page 137.
2001 regulation.
What is that?
That is the Milord, the
3rd September 2001.
সবাই মিলে কথা বললে কোর্ট হবে কি করে?
3rd September 2001.
This is the Milord, the qualification regulations may be called National Council for Teachers Education Determination of Minimum Qualifications for Recruitment of Teachers in School
So
Regulation.
you are referring to which particular regulation?
Milord, kindly see that your lordship will not find TET mentioned.
No. Of course, 2001, TET was introduced only after the RTE Act.
Right so.
So 2001, TET was unknown.
What I
It was
say,
unknown.
that's why Milord, these notifications will give exemption to the teachers who were appointed Milord, prior to the knowledge of TET.
Very good.
And this exemption Milord, was considered by your lordship. Kindly turn to Milord, my lord's own judgment,
Yes.
para 168.
That has been placed just now by Mr.
Just, may I just repeat? Kindly, page para 168 is very important.
Page 90.
Page 90. Well, I will read it a little slowly for my benefit. Milord, I would rather read 167 to Milord, my lord's reasoning to arrive at 168. Importantly, the first and second proviso to section 23(2) of the RT Act carve out a transitional obligation for in-service teachers who did not possess the minimum qualifications at the time of commencement of the Act. They were required to acquire such qualification, including passing TET within a prescribed time frame. The second proviso introduced by the RT Act extended this compliance period by a period of 4 years from the date so and so. The express legislative intent was to bring in all service teachers within the ambit of uniform quality of standards. Then, NCT's notification also reinforces this requirement by stating that the teachers working in unaided private schools, or those already in position on 31st of March 2015, must qualify the TET with the stipulated period. The language of both RT and the notification leaves no room for ambiguity that even those teachers appointed prior to RT, if not qualified, well, this is important, if not qualified, must meet the TET requirement within the grace period. Only those appointed prior to 3rd September 2001 in accordance with the applicable recruitment rules or those covered by specific exceptions were exempted. Milord, this is the finding of the Honorable Court, which Milord really supports my cause. But Milord, this is my misfortune, but in the direction portion,
This is just noticing the relevant statutory provisions.
Right, so.
And ultimately 23 subsection 2 second proviso, pins you down.
The second proviso pins me down, I have no quarrel, but that will not empower the...
Because whatever exemption is given under a notification cannot override the statutory provision.
My lord,
NCT cannot grant an exemption which the legislature is not providing. The will of the people has to be respected, Mr. Bhattacharya.
the deepest of respect, Lord, I just...
Right? And you are expressing the will of the people
I am.
presently.
Now, I am trying to point out, Lord, that the statute says it depends upon the academic authority. It depends on the academic authority.
We will consider.
The academic authority felt it. Academic authority felt it that these people need not go to TET.
Well,
I can also not concede to the extent that if the court feels that they should update their skill, let them do it. But that should not be coterminous with their recruitment. That would be too atrocious.
Very. Thank you.
Lordship,
I have
give the same benefits that is given to the others, that you may not get promotion.
Well.
But you,
I'll just state the two submissions. First of all,
Who are you appearing for now?
Milord, State of Tamil Nadu,
Just
same,
written by State
yes,
of Tamil
yes.
Nadu. Very well.
and Milord, I
We have been hearing from the morning
yes.
adjournments because
Change
there
of
will be a new problem.
Milord, your Lordship is not going to adjourn this matter, Milord, so we better be here. Now, Milord, I appear in 14 matters, Milord, but the list is there. I don't have to
Very
give
well.
it.
For State of Madras.
For State of Tamil Nadu.
State of Tamil Nadu.
2 points, Milord.
Yes.
By directing compulsory retirement, your Lordship has interpreted the second proviso in such a way that it introduces an eligibility condition decades after the person went into service. Now, even though this may be for the benefit of the students, it goes against a very fundamental principle of service law, which also must be applied. That's my first submission.
may I take
Second, my lord.
May I take leave?
Second thing is this, my lord. We have given the facts. For 4,49,850 teachers in total in the government in Tamil Nadu. 3,28,701 not qualified under TET. In 2 years' time that your Lordship has given us, my lord, it is administratively impossible to repopulate, my lord, the entirety of the service.
Statute gave you 2 years in 2017.
My lord,
We have given 2 years in 2025.
no, my lord, no, my lord.
If your teachers do not equip themselves, Mr. Gupta, we wouldn't expect the state of Tamil Nadu to
My lord, would your Lordship, my lord,
come
kindly,
forward on behalf of the teachers.
no.
By now, there may be several
my
lakhs
lord,
of
just kindly
teachers.
permit me to end my submission.
Right.
The difficulty is, my lord, if it's administratively impossible to repopulate the service, my lord, then the schools have to be shut down. That's what I'm trying to say, my lord. And my lord, your Lordship's help,
What happened in 2017 when this notification came?
it wasn't interpreted to mean what your Lordship has now said.
It is
Your
very
Lordship has
clear.
interpreted
is
it for the
very
first time.
clear. It is very clear.
It may be, my lord, clear to your Lordship, my lord.
Required no interpretation, but the court is forced upon
However-
to interpret a plain and simple statutory provision.
All I'm saying, my lord, is kindly give us at least 4 years' time. Otherwise, administratively, my lord, it is impossible and the schools will have to shut down. My lord, this is in grounds 4 and 5 of my review, my lord.
4 years' time.
Yes, my lord.
We'll keep in mind.
Lordship.
Yes, Mr. Patel.
I am for the teachers in the state of Jharkhand.
Achha.
We have-
Just 1 minute.
Sorry.
What is the cause title of your petition?
Cause title is, my lord, Akhil Jharkhand Prathmik Shiksha Sangh.
Akhil?
Akhil Jharkhand Prathmik Shiksha Sangh. It is
Akhil
301.2.
दो नंबर में है.
.2. We are teachers, my lord.
Acha. Akhil Jharkhand Prathmik Shikshak Sangh Jharkhand.
Correct.
You have raised 7 points.
Correct.
Oversight of NCT notification which exempted pre-2010 appointees from writing.
I am
test.
starting from
First, court misconstrued RTE Act 17. Intent was never to retrospectively impose TET on teachers appointed prior to 10. Executive clarification dated 3rd August 17 to the effect that teachers appointed prior to 2010 need not acquire this qualification. Rule 9 of RT amendment rules violated. Our interpretation has violated rules very well.
Yes,
Pre-2010, this is what we have culled out from your petition.
Correct.
Treating pre-2010 appointees with post-2010 appointees amounts to hostile discrimination, violation of 14. 6. Appointees fulfill the eligibility conditions when they were appointed under the relevant state rules. This is the common submission. And new promotion rules 2025 of the state has granted exemption. So state law will override a central law.
So, my lord, I am not going to argue all that.
So which one will you argue? Tell us out of these 7.
My lord, the point I am essentially placing before your lordships is that your lordship's judgment now, as my learned friend Jaideep just said, your lordships are virtually imposing a new condition of eligibility by a judicial interpretation, which if possibly the executive had done by a service rule, may have been liable to being struck down by your lordships. And realizing this, my lord, one line of the 2010 notification has been probably overlooked or missed. Please see page 42. We are people who were recruited from 91 to...
You are referring to which regulation?
Yes, please see page 4. I am referring...
No, we are not looking into every petition because there are more than 100 petitions. It's absolutely impossible to have 100 petitions.
31st March 2010 notification prescribing the qualification.
31st March 2010. It's not in this compilation. Do you have a copy?
In your lordship's judgment, I only have a soft copy. In the judgment at page 41, it is reproduced.
Page 41.
41.
Page 40. Just see paragraph number.
Para 62.
Para 60.
The reference comes from para 61. This is under that heading where acts and notifications where your lordship have done. Now, please see para 61. Your lordships have said central government notification dated 31st March 10 appointed NCTE as the academic authority. Then thereafter, the 23rd August 2010 laid down minimum qualification. This is what I am reading. Please have the next page, para 4, teachers appointed before the date of this notification. The following categories of teachers appointed for classes 1 to 7 prior to the date of this notification, we are that class, need not acquire the minimum qualification specified in para 1 above, and C, a teacher appointed before 3rd September 2001 in accordance with the prevalent recruitment rules.
Right.
Now, this recognizes a very established principle of service jurisprudence which says that your conditions for eligibility for appointment, your lordships have subsequently said promotion will be included in appointment. I have no quarrel with that. Perhaps I may not be able to get promoted till I acquire the TET qualification. But the question is, would my original appointment be also under jeopardy on account of a qualification which is laid almost a decade after or 2 decades after I have come in? And according to me, my lord, the central government has saved us under para 4 subclause C. And once...
Some notification which is prior to the statutory amendment. Statutory amendment has not been challenged. That is of 2017.
That is the fresh notification.
Look at para 69 of the judgment.
Correct.
The executive has written a letter.
Correct.
Just turn to para 69
Yes.
of the order. Please read it.
I'm reading it.
Yes.
On 3rd August 2017, the Additional Secretary, Ministry of Human Resource Development, Department of School Education and Literacy issued a letter to the state secretaries reminding them that the last date to acquire minimum qualification is 1st April 2019 and no teacher who did not possess the qualifications under the RTE Act would be permitted to continue. So, my lord, this would have to be read.
My brother has been more than benevolent.
This has been informed as far back as on 17.
I do understand.
Therefore, the executive stand was also this before us, that this qualification is mandatory. It had to be acquired within 2 years of 2017. My brother has said it's not required for people
I do
retiring
realize, my lord, I was,
within 5 years. Then even till 5 years, you got it in the next 2 years.
my submission is,
Extension of time.
my submission is that if we are exempted under the basic notification, all subsequent
this is
statutory
now-
regime will not come.
That a notification has to yield to the law.
You're not looking at this statutory amendment of the Act.
Statutory amendment.
My lord, then
Your
that will
readings of
relate back to
notification.
this act itself. It will not cover a
Statutory
person.
amendment, if it had not had those words, 3rd March or 31st March 2015, we could have interpreted it otherwise. We have put these review petitions only to get assistance from you. How do we interpret
My lord,
the second proviso in a manner different from the one
my reading is,
in which we have
my
interpreted?
reading is that if a person is already excluded from this whole new statutory framework, then any subsequent amendment or proviso will not bring him in, my lord. That's all that I'm trying to say.
That's next in seniority,
I go in.
Mr. Giri.
Yes,
Very grateful, my lord.
301.8.
What is the name of your client?
Meghraj Singh and others.
Devrat Singh. Devrat-
Title starts from page 111.
Just one. Devrat Singh. Meghraj Singh.
Yes, my lord.
Meghraj Singh.
My lord, altogether 232 petitioners.
Deprivation of livelihood, retrospective application is irrational. Education is a state subject. State laws predate RTE. Education is a concurrent subject, the state subject. Of notification dated 23rd August 2010 exempted teachers appointed prior to the notification. Proviso to 23(2) provides for acquiring minimum qualifications within 4 years for teachers appointed prior to coming into force. That was not a minimum qualification. These are the grounds that
These are the grounds. My lord, they have been argued in one way or the other.
it has
Right.
been argued.
And therefore, my lord, why should I take up your lordship's time on that?
Right.
But please come to the section.
Yes.
Because this is where your lordship seeks some,
Please, we want
Some
assistance on 23
yes.
to second proviso.
My lord, this is something, my lord, which I am advancing before your lordships. Because this is a manner in which if it is read in this manner, probably many of us come out of the net as such. Please come to section 23 once more.
Yes, we are on 23.
My lord, this was there right from the beginning. That is from 1/4/2010 onwards. Any person possessing such minimum qualifications as laid down by an academic authority. Academic authority, my lord, is also subsequently defined
As NCT.
as NCT. Authorized by the central government by notification shall be eligible for appointment of a teacher as a teacher. My lord, subsection 2 may not strictly apply, but for the sake of completion, let me just read it. Where a state does not have the adequate institutions offering courses or training in teacher education or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years, as may be specified in the notification. My lord, the second proviso was not there. Probably addition of this or bringing in a qualification, my lord, post prescription of the qualification as per a notification dated 23/10/2010 might have been ultra-wise. But your lordships are right. There is a substantive plenary amendment. Provided that a teacher who at the commencement of this act does not possess minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. Suppose we stop with that. Then also, my lord, all those persons, these 232 persons, like several others, they were all appointed prior to 23/10/2010. They were appointed prior to 1/4/2010. There were many of them are appointed in 2001 and up to 2009. Therefore, my lord, the first proviso also does not hit them in that way.
No, it hit them. They did not realize it. Because they were teachers. It says provided that a teacher,
Yes.
not a person. Person is referred to in 23(1).
Yes.
First proviso does not refer to person.
Yes.
It says provided that a teacher
Yes, my lord.
who at the commencement of this act, that means 1st of April 2010,
Yes.
your client is a teacher
Yes,
and does not possess the minimum qualification under 23(1)
yes,
shall acquire such qualification within a period of 5 years.
that's right.
So you are a teacher in position on 1st April 10. You are given 5 years time to qualify.
My lord, the minimum qualifications laid down in the subsection 1 is by means of a notification.
Right. So
Insofar as the first proviso
that
is,
comes on 23rd August 2010,
that's right.
right? So 5 years cannot be counted from 1st of April. 5 years will obviously have to be counted from the date of the notification.
Correct, my lord. No,
So you are a teacher.
no, my submission is this, my lord. My lord, first proviso therefore says, possesses minimum, sorry,
For me, qualification, the minimum qualification prescribed is at times.
first proviso therefore says, who at the commencement of this act does not possess minimum, as laid down under subsection 1. Now, who lays down under subsection 1? As per a notification. The notification under subsection 1, which has actually continued to remain from 2010 till date, is a notification dated 23/8/2010. My lord, what your lordships have seen, the,
First April, if I'm exempted, then it will be. And this now would be different. And this for people who are exempted.
That also covers.
yes, no, my lord,
You're saying that
my lord, the 23/8/2010 notification will have to be read into subsection 1. Because subsection 1 contemplates that there has to be a prescription in terms of a notification. If you read the notification dated 23/8/2010 into subsection 1, section 23(1), then first proviso would also draw sustenance from that.
First proviso may draw sustenance, but the problem is the first proviso uses the expression commencement of this act.
Yes,
Commencement of this act is 1st April 2010,
yes,
not 1st August 2010.
no,
So therefore, the qualification which is prescribed on 1st April will have to be met by the first proviso. The second proviso is talking about the cutoff date as 31st March 2015.
can I come
By
to,
that time, this
I'll come to
NET qualification has come in.
I'll
TET
come to the
qualification has come in.
I'll come to the second proviso in a moment, my lord, because I made this submission and my lords felt, I am also hit by subsection, the first proviso.
Both 1, 2.
That's right. Therefore, insofar as 1 is concerned, please read the 23/8/2010 notification into subsection 1 and please have a look at the notification. It's not a question of exemption. Prescription comes under the 23/8/2010.
The second proviso is a complete knockout punch.
No, Lord, I'll come to,
No, you don't forget the background. You're on the background.
Lord, I'll come out. I'll come to the second proviso in a
Come to
moment.
the second proviso, right?
I'm anyway tottering on the ropes. Therefore, my lord, let me come to the second proviso in a
There are other council.
I'll just take a minute.
Yeah,
I'll just take a minute.
You, but just
I understand, but I'll just take a minute. The notification dated 23/8/2000, this is my submission.
yes.
Notification dated 23/8/2010 will have to be read into subsection 1. It has to be read into the proviso also. When your lordships read the notification, your lordships will have to, because the prescription contained for minimum qualification in the 23/8/2010, this is where TTE comes in, comes about under the 23/8/2010. There is no plenary statute prescription for TTE, nowhere. And then when your lordships come to clause 4, training to be undergone, clause 3, then clause 4, this is also a prescription, not an exemption.
Very
The following categories of teachers appointed for classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified in para 1 above. And then, my lord, the prescription comes about. Lord, is it to be construed as an exemption? Because where does 23(1) says exemption? 23(1) says prescription. And prescription would include whatever is mentioned in clause 4. If the prescription contained in clause 4 is...
Was NCT conferred any power to grant exemption?
Lord, if it is not...
How could NCT grant exemption? being a delegated authority,
No, my lord,
it could not have granted. It could not have granted.
and therefore, my lord,
So,
they said-
so the parliament in its wisdom thought that it is better to make it absolutely clear. Second proviso is inserted with effect from 2017, requiring every teacher in position on 31st March to possess this qualification.
please come to the second proviso then.
Please read it.
Yes, provided further that every teacher appointed, my lord, would it mean appointed in terms of the provisions of the Act? Because the Act does not have any retroactive operation. It cannot go beyond 1/4/2010
Or in position as.
or in position as on the 31st.
Position means not appointed under this act.
No.
Maybe prior to the
Maybe
act.
prior to
No,
that.
my lord, as in or on,
Please,
my lord,
Mr. Giri, we are pointing out. Look at it from the perspective of a child. He needs a good teacher. He needs good quality education. If the teachers are lacking in education, how will they be able to teach the next generation?
my lord,
We have looked at it from this perspective. That's
Lordships
what my
are-
brother,
and
we
our-
must tell you where
lordships
we
are
are.
bound to.
No,
Lordships are bound to look at the holistic picture.
Ah,
We may not be, but I understand, my lord, therefore, what your lordships are having in mind. But appointed means appointed in terms of the Act. But can the word which come after that, in position on the 31st of March 2015, would it take in persons who were appointed prior to 1/4/2010?
We'll consider.
Who does not possess, yes, my lord, just one moment, my lord. Who does not possess minimum qualifications as laid down under subsection 1. And therefore, my lord, please read the notification again as part of subsection 1. If your lordships are pleased to read it that way, then the qualification that we possessed, which is treated as qualification in terms of the clause 4 of the notification dated 23/8/2010, will have to be treated as sufficient for the purpose of proviso 1 and proviso 2.
Very good. Thank you.
My lord, this is what we wanted to say.
Yes,
My lord,
Mr. Jha. We believe you are next in seniority.
Lord, there is,
Mr. Khurshid, you came just now. They have been waiting for some time.
yes. Lord, can I?
I'm
30 seconds, my lord.
Oh, he has been sitting right from the beginning. Sorry, very sorry. We didn't see you. Very well. Otherwise,
I didn't know, Lord. Otherwise, I would have given way, my lord. I would
Address us first. Nobody told us.
have given way. I didn't know.
I was asking, I've asked my friend to go first.
I
Just
said-
as the correct.
Lord, can I can I just take one more minute, my lord?
You
This
just now said 30 seconds. And now you make it double.
17/10/2017, there is a notification under 23, under section 18. 17/10/2017. It's part of my additional documents.
Very well. What does that
It amends, my lord, the rules of 2017. There is an explanatory memorandum to this. My lord, lordships could always look into the memorandum for the purpose of sustenance,
Very
though it doesn't govern it.
Very well.
Last line, my lord, in the memorandum says, in providing retrospective effect, interests of no person shall be adversely affected.
Very well.
Please bear that in mind also, my lord, is my respectful.
see, it was interest adversely affected. You want to take a qualification, take it. Prospectively, you can always.
No, my lord, in the- my lord,
Mr. Jha, we'll call upon you after Mr. Khurshid.
My lord, my lord. I wait,
I'm grateful. I'm grateful.
wait my turn, man.
Well, it's grateful. Well,
You appear for whom?
two very short points, Mullers. I mean, item.
No, not the item. You have to
All
make
right.
the
First
party.
for Meghalaya Sarv Shiksha Abhiyan School.
Meghalaya. मैडम इसमें से मेघालय ढूंढिए ना मैडम कौर नहीं इसमें अलग से ऊपर नीचे हो गया है मेघालय व्हाट इज
It's called Meghalaya Sarv Shiksha Abhiyan School.
सर्व शिक्षा
Sarv Shiksha Abhiyan Schools Association.
देखिए तो स्टेट यस स्टेट मेघालय
Mr. Advocate General is here, Mullers.
सर्व शिक्षा अभियान स्कूल्स एसोसिएशन So, sir, your points raised in the review petition are these.
Please, Mullers.
There was no TET when the petitioners were appointed in the state of Meghalaya. MHRD's notification dated 3rd August 2017 recognized that the existing in-service elementary teachers who lack the minimum professional qualification should be provided a transitional opportunity for upgradation rather than being summarily removed. Third, the judgment under review conflates both eligibility qualification with quality evaluation. These are the 3 points.
Those are the 3 points. I'm just very briefly going to touch upon 2 issues. One is your lordship's judgment itself, paragraph 169.
Para 169.
Your Lordship will just allow me to read paragraph 169. It begins at 168 and then 169. Last three lines of 168.
This one. And
Yes.
Begins with only those appointed prior to 3rd September 2001 in accordance with applicable recruitment rules or those covered by specific exemptions such as special BTC or DED courses, etc., were exempted. So there was an exemption. Your Lordships have recognized that exemption. People appointed prior to 3rd September 2001. Thereafter, my lords, your Lordships then say, thus read holistically, Section 23 of the RTE Act and the NCTE notifications together establish that TET as a compulsory qualifying criteria for all teachers appointed on or after 23rd of August 2010, and as a time-bound compliance obligation for those appointed earlier without the requisite qualifications. My only submission is requisite qualifications does not include TET, but if your Lordships have written this judgment, your Lordship knows better what exactly it means. But that's my submission, my Lords, the way I read it, is that it does not mean TET, it means any other qualifications that they don't have, they've been given a compliance period.
Very good. Thank you.
Then, my lords, just through three more lines. The sole object is to ensure uniform teaching standards across institutions, etc. We bow to that. My lords, your lordships have made this point about how does a notification bypass a statute. But there are two statutes involved here. One that I believe has not been taken.
NCTE Act.
My lords, the RTE Act. My lords,
RTE Act and the NCTE Act.
12A. And
12A is NCTE Act. 12 capital A is of NCTE.
12A capital is NCT Act. Mullahs, I just want to read out the proviso there. If your lordships will see 12A. Mullahs, the proviso only says, provided that nothing in this section shall adversely affect the continuation of any person recruited in a pre-primary, primary, upper primary, secondary or intermediate schools or colleges under any rule, regulation or order made by the central government, a state government, Educational Amendment Act 2011, etc., solely on the ground of non-fulfillment of such qualifications as may be specified by the council. So 12A, next proviso.
Well,
I'll read the next. Provided further that minimum qualifications of a teacher referred to in the first proviso shall be acquired within a period specified in this act or under right to children to free and compulsory education act. If your lordship read that with my interpretation of paragraph 169, it is qualifications that have to be complied with in that period, but RTE is not part of those qualifications. That's my submission, my lord. I'm grateful, my lords.
Yes, Mr. Jha, who do you appear for?
My lord, I appear for the tribal.
I have one suggestion.
Not just
Of the teachers. I'm grateful, your lordship, permitting me to appear through the.
Yes, please. You are appearing for which state or?
I'm in item number 301.68 for the Tribal Welfare Teacher Association of Madhya Pradesh.
Tribal Welfare Teacher.
Teachers Association of Madhya Pradesh.
एक बार देखिए ना इसमें कहाँ है? Tribal Welfare
Teachers Association.
मध्य प्रदेश के आसपास ही होगा.
Yes, ma'am.
अच्छा, point, sir.
My lord, your lordships, I wanted to assist your lordships in interpreting the proviso.
Yes.
Both of them. And since your lordships have positive time, just read it, my lord. Provided that the teacher who at the commencement of this act does not possess the minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. And the second proviso says that as on 31st March 15, who are there, if they don't possess it, they will acquire it within 4 years. Now, the section statutory provision says qualifications as laid down under subsection 1. Now, the qualifications that have been laid down under subsection 1 are under the notification of 23rd of August 2010, which your lordships have reproduced, considered on several occasions. But there are certain aspects of it which I want your lordships to just see along with me, my lords. Here, my lords, if your lordships will see this notification, there are 4 categories of teachers here, not a single category.
Yes.
So that he's saying.
The first paragraph, my lord, deals with the qualifications that are prescribed for fresh recruitments after the coming into force of the Act. And if your lordships will see under the first paragraph, and TET, which your lordships are concerned, and TET, along with certain qualifications that are mentioned, senior secondary with certain 50%, etc. And in both cases, A and B, it's and TET.
Yes, pass in the teacher eligibility.
Yes, ma'am. Then if your lordships will turn to paragraph 3 of this notification.
Paragraph 3.
Paragraph 3.
Yes. Training to be under.
Yes, ma'am.
Training to be undergone.
Yes, ma'am. It says with BA, BSc. Now, this is something apart from what has been mentioned in paragraph 1. BA, BSc with 50%. B.Ed qualification also eligible for appointment to class 1 to 5 up to January 2012, provided he undergoes NCT recognized 6 months special program elementary education. So even those who don't possess the qualification prescribed in 1 but are BA, BSc with 50%, if they undertake 6 months training, they are qualified. Same is with D.Ed, that is in B. Then 4 comes another set of teachers. They say the following category of teachers appointed in class 1 to 8 prior to the date of notification need not acquire qualifications specified in 1. And here 3 instances are given. Teachers who are appointed.
But sir, your contention overlooks the minimum qualifications which are prescribed under paragraph number 1. Paragraph number 1 deal with minimum qualifications.
My lord.
Minimum. These may be additional qualifications that are required. Diploma, degree course in teacher education. But the minimum is you must have for classes 1 to 5 secondary or senior secondary or senior secondary. Either of these 3 plus TET. Which is for classes 1 to 5. For 6 to 8, you require BA, BSc or again BA, BSc or BA, BSc, senior secondary or senior secondary or BA, BSc. These alternatives are there, but pass in TET is the mandatory qualification.
My lords, my respectful submission before your lordships.
You cannot say that if somebody has the qualification in 2, he may not have the qualification in 1.
The reason is, my lord, that the competent authority, that is NCT itself, saying that if these people possess this training, B.Ed, which it has prescribed previously, if they undergo 6 months special training, that is a BTC training which is prescribed there, they will be deemed to possess the qualification prescribed under subsection 23(1). And for these teachers, these 4 categories mentioned in paragraph 1, 3, 4, and there's a 5th category which says that those teachers whose recruitment started prior to the coming into force of the Act and were recruited under the regulations of 2001, they also will not be required to have the qualifications mentioned in para 1. So my respectful submission before your lordships is that the proviso says qualifications laid down in subsection 1. And the qualifications that have been laid down in subsection 1 for us who were working for a very long time is covered either under para 4, 5 or para 3.
Very well.
Para 1.
We have noted.
There's another very big difficulty in Madhya Pradesh. In Madhya Pradesh, the recruitment rules that were existing at the time when we were appointed did not require 50% in higher secondary for appointment. It was simply higher secondary pass. Now at this stage, if your lordships relegate us to TET, we will not even be eligible to participate in TET because we don't have 90% of the teachers of this association who are working in tribal areas. don't even have 50% at that time because they were appointed 20 years ago.
Our order only says that you need to qualify in the TET. At this age, you will not be required to go back to the high secondary level and cross 50%. That is not the purport of our order. Our purport of our order is, if you are a teacher in position, if you have not acquired TET by now, you do it by 1st of September 2027.
No,
you are not required to go into this 50% higher secondary pass qualification at this stage.
But these authorities, my lord, here in Madhya Pradesh, when they are drawing up people, the list of people who to go through this, they are looking at this 50% qualification and saying you are not qualified.
If they look at it and if you are, if it is applied against you, you may seek your remedies before the appropriate forum. Thank you very much, Mr. Jha. Thank you very much.
There was Lord, one submission. State of Meghalaya. Only one
another issue here.
submission.
Just 1 minute. Yes, yes. Yes.
One extraction. I beg your lordship's indulgence.
Yes, yes.
My lords, in the state of Madhya Pradesh, there are certain scheduled tribes, and they are Baigas and others. And when teachers were appointed there, the state government has enacted an act, statutory provisions for tribal welfare. Under that act, these teachers were given exemption from acquiring necessary qualifications for appointment. Now, I have given a list of teachers who were appointed as teachers and are working there in these tribal areas. They are tribals for the last 20-25 years who do not have this qualification, and they are going to go out simply because now your lordship say that TET has become, though TET is not there in the statutory provision of the act itself, it's prescribed by the notification. So, my lords, my submission is that these people would go out straight away. And this tribal area where no teacher is willing to go, where schools are not even available, infrastructure is also not there. And these teachers have been, for the last 20-25 years at least,
But if there are qualified teachers who cannot be appointed because of dearth of vacancies, definitely they will be going.
Nobody is willing to go area. Nobody is willing to go and work in tribal areas. That's why, my lords, the non-formal education.
If this submission is accepted, then after 2010, anyway, no teacher can be appointed for a tribal area.
My lords, this is the factual situation in Madhya Pradesh.
This is all an emotional argument contrary to law. This cannot be accepted. Then after 2010, no recruitment is taking place for tribal areas.
I just point out. If your lordship will give me a minute, I have filed documents.
It doesn't sound tenable at all.
No, my lords, it's not my submission. It's the government's own stand as that documents to indicate.
Very well. Thank you very much.
We have understood.
Thank you very much. Yes, Meghalaya.
One alternative submission, my lord.
Yes.
We have total 38,256 in-service candidates.
How much?
38,526.
38,500?
38,256, my lord.
256.
Out of which we have...
You are representing the
state of Meghalaya.
State of Meghalaya.
Yes, my lord. And out of which we have 5,912 MTAT qualified teachers, my lord.
5,912?
5,912.
TET qualified?
TET qualified teachers.
Right.
We are holding the examination, my lord, on a regular basis. We would be requesting that some sufficient time may be given so that we can comply with the order.
So our order is, the
only
time
for
is
1st
31st August 2027.
Yes, my lord, 2 years, my lord. We have
2 years. In 2 years' time, you conduct two examinations.
We have been conducting the examination, but we have got Garos and Khasis region, my lord. Yes, we are holding the examination.
For exams?
The issue is, my lord, that Garos and Khasis are tribes and we have got the local languages. To filling up those vacancies, my lord, in 2 years may be difficult. We are asking for some more time so that we can comply, my lord.
Well,
I understand
the 17 till now, 20.
Yes, I understand, my lord, that judgment came on 1st September 2000.
But this was the statutory provision.
Yes, my lord, that I have seen and
implementing the statutory provision.
Yes, my lord. The only difficulty is that if this is implemented, we have
between Mr. Rahim and Madam Mona, who is senior. Yes.
I only look old, ma'am. I only look old.
You look old.
She looks younger.
Thank you. Lord,
you are for whom, madam?
Lord, I am appearing for all postgraduate teachers welfare association, item number, my lords.
All postgraduate teachers welfare association.
Item number 301.54. 301.54. Teachers of West Bengal, my lords.
West Bengal?
Yes, my lords.
1 minute.
Postgraduate on honors, my lord. These teachers are all, actually they were recruited for up to higher secondary. Not in West Bengal, your lordship may probably know that there is a category called normal teachers, and there are separate teachers for primary, upper primary.
Normal teachers?
Normal teachers as meant.
I have not heard about normal.
There are notifications by the government also.
What normal teachers, Mr. Rahim? Have you ever heard?
There are notifications. Normal
teachers,
sections.
Where is the other category?
Normal sections are.
What
they
is
are,
the other category?
They are called primary and higher secondary. These normal.
No. We have not heard about normal.
Very well, not. These are categories. We were all educated for post-graduation also, for teaching post-graduation also. Our problem is, one problem is a peculiar thing that I will come in the end note. Here, when I am reading section 23, your lordship's first question was, will you please satisfy what is the second proviso up to? I will try not to satisfy that. This will not be applicable.
Please.
But I will read the section again. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. So any person who fulfills will be appointed as a teacher. Where a state does not have adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualifications as laid down in one or not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. In this, my lord, stopping here for a moment, there are 3 stages at which, my lord, they can extend. One, my lord, when the notification newly coming and the act is new, my lord, then there is no provision by the state giving you more institutions. There are no colleges offering this education. There are no courses or training for this teacher education. Therefore, my lord, this 5-year period from the date of the enactment came in. Now, when within the 5 years also, my lord, provided that a teacher who at the commencement of this act does not possess minimum qualification laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. This is what was read in that notification, a subsequent letter which government clarified that this is not applicable to the in-service candidates, which was read out before your lordships. Your lordship's query is provided further that every teacher appointed or in possession as on 31st March 15 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement. Lord, this has been given only with a view to this 15 is a 5-year period which they fixed from 10 to 15. The act came in 2010. It gave, the first proviso gave 5 years time to fulfill the qualification. So therefore, my lord, within the 5 years, since there were not many institutions offering this course or not unable to complete the qualification which is prescribed by this enactment, your lordships are seeing even today, states are coming up and saying we are unable to make up this institution, making them get educated for TET. So the likewise, my lord, it's a new enactment, and since even the new teachers who are recruited and in place in 2015 unable to acquire TET, therefore, my lord, this proviso 2 was introduced in my humble submission. It is not that a proviso which was actually a benefit which has been granted to in-service candidates could have been again revived by the second proviso. It could not have been revived, my lord. Number 1. And then, my lord, I am only reading the one again, is that a person possessing such minimum qualification as laid down will be eligible for appointment is there. It doesn't say shall be eligible to continue as a teacher. If at all the enactment wanted me to go out when I don't have the TET or the qualification which is prescribed in this section, the section 1 should read like this: shall be eligible for appointment or to continue as a teacher. Since there is no such, my lord, prescription in this enactment, this honorable court, my lord, in my humble submission, could not, my lord, presume a retrospective application of this act. Your lordships are aware, my lord, I can't carry coal to Newcastle. Devin Katti principle, which is till date we not pursued, followed by this honorable court, is that when an advertisement is issued, when somebody is recruited, you have to only go by the rules then in existence. You can't subsequently, after a person joins a service, you cannot now retrospectively apply a rule which is now introduced. And then, my lord, for the basic service law principle, my lord, this will be, if this interpretation, if it is given, that even to continue as a teacher, this provision will be applicable, will be contrary to the basic principles, in my humble submission. Your Lordship will also...
Thank you, madam.
Lord, just one more, my Lord.
Thank you.
Lord, the normal section is what the West Bengal says is that, my Lord, our appointment itself is for the High Court judgment also in several cases mentioned that is a normal section will include from 5 to 10, my Lord, class 5 to 10. The peculiar problem for West Bengal teachers today is that, my Lord, we were teaching up to 10th. In fact, we can teach higher secondary also. But due to this bifurcation, my Lord, now they are made to teach only upper primary, asking me to now get a TET qualification, which is peculiar to West Bengal, my Lord. I am a postgraduate with the training to coach, my Lord, even the higher secondary. So therefore, we have a problem.
Thank you, madam. Yes, Mr. Rhyme. Who else is there senior to you?
Who is of course also retired.
I'm simply
Acha, Mr. Gangle is there.
301.62.
Acha.
My Lord,
You are appearing for?
301.62 intervention applications on behalf of the teachers. Lot of arguments have been argued, my Lord. Only this, your Lordship has also said, pointed out in the para.
Acha, this is this serial number?
301.62 intervention
application in 301.62.
on behalf of
Yes,
teachers,
yes, please.
700 teachers.
Yes, please.
Prior to 2001, they were appointed. And in para 62, your Lordship has already quoted, and that has been argued. 4, and there is an exemption of TET. My submission is this, that we are exempted in accordance with that. TET is not required. Second point is this, that Article 309(11)(2), it is a status and it cannot be taken away. The main argument is, as I was hearing, that looking to the teachers' efficiency, this examination is necessary. It is a dangerous trend. It can be in every service. That is the main point.
21A has been brought in with a purpose, sir.
So, my Lord, then to every service.
Very well. Yes, Mr. D.S. Naidu now.
May it please, Millets. Millets, I represent the teachers from the state of West Bengal. And they were all... Please.
Mr. Rahim, Mr. Bhattacharya, Madam Mona, you also.
Yes.
Only 1 minute. Lord, it just shows me, Lord, that the teachers over there. It just shows me, Lord, that the apathy of the teachers over there, how they are affected.
Because, my Lord, the state of West Bengal and board has not come out.
Nice. Millets.
Well, just 1 minute. Let Mr. Naidu come. Today we will not.
If I'm permitted 30 seconds, Millets.
Yes, yes.
If I'm permitted.
1 minute.
No, Millets.
1 minute. No. Because we are hearing the same argument again and again.
Yes.
We have been indulgent, but that does not mean Mr. Naidu.
Absolutely, Millets.
Right,
I can
that
never
same
hope for your
argument
Lordship's
will be,
kindness. But my Lords
presented
have...
for us in a different language.
Compensation.
Just 1 minute. This is a review. We have heard from 2 o'clock. Right?
We are all great.
The review, the error has to be such that it does not require more than a minute's argument to demonstrate.
Precisely, Millets. Would my Lords have, since I have taken the SEC copy of your Lordship judgment...
No, we have the SEC copy.
Yes, Millets. Would my Lords come to para 90?
90?
90.
That is the bedrock of the judgment.
That permeates...
Para 90 is the bedrock of the judgment.
Indeed, Millets. That's why I begin with that one. That permeates the spirit of the judgment. And my Lords have taken recourse to, in my humble submission, a purposive interpretation coupled with Hayden's principle of curing a mischief. This is one thing. And Millets, the question that I may have to pose myself is this, Millets. Can a qualification which has not been explicit be read into any recruitment?
2017, this proviso was brought in.
Yes, Millets.
Right. Why did you not challenge it?
Obviously, Millets.
Why did the teachers not challenge it? Just tell us this. Yes. It has been almost 9 years on the statute book. The parliament wanted to give 4 years time, but it is brought into effect with retrospective effect from 15, thereby curtailing that 4 by 2 years. And even then, West Bengal teachers, they did not rise from their slumber.
My answer is this, Millets.
But now everybody...
We have never...
Now everybody. What now everybody? What is the...
Millets?
If we interpret the law as you are asking us to interpret, this second proviso will be rendered redundant.
May I say with great respect, Millets, the only difference between first proviso and second proviso, as I understood, was that, Millets, whatever the time frame that was given, there were representations from various states, and it was extended. So the first proviso, if good enough, the second proviso is only otious, except for certain categories of extension of time.
Proviso makes it absolutely clear.
It's been made explicit, Millets. It's been made explicit what is
was
implied.
there in first proviso.
Yes, Millets.
That ambiguity is removed by the second proviso.
Millets, that's what I say, Millets. It's only clarificatory in nature rather than giving anything extra, barring the time frame that's been extended. My humble submission is this, Millets, that has been repeated, that the section does not, or rather the article and the section, they do not read anything vis-a-vis the qualification or minimum qualification. I was recruited, we were all recruited for that matter, between 2001 and 2010. Then Millet's 2010 rules superseded. Then 2011 there was an amendment. Eventually 2014 was the culminating factor. Millet's amendment or no amendment, my submission is this, Millets, all through I've been qualified when I was recruited. And Millets, I've had a vested right in the process of my recruitment and my appointment. And Millets, any rule or regulation which has come in effect, if that supersedes something else, Millets, the vested right in terms of Section 6 of General Clauses Act cannot be diluted. This is my humble submission.
Very good.
Lord, only, Lord, I will not repeat anything, Lord. I will not repeat anything. Lord, your Lordship may kindly see, Lord, your Lordship, Lord, at the heart of the judgment, my Lord, is the fact that your Lordship mounted, my Lord, uniform teaching qualifications, A, and your Lordship said, my Lord, that TET is a constitutional necessity. For which reason, my Lord, Article 21A, and my Lord, the provisor, my Lord, your Lordships have, my Lord, held it very firmly, my Lord, and rightly so, my Lord. Now, my Lord, today, my Lord, the ground reality is this, my Lord. In Bengal, my Lord, the first TET was held in 2014. No, the exam
will change now.
No,
hopefully.
I'm saying,
hopefully.
We all pray for that. We all pray for a better.
Let us hope for
yes,
change.
Of course, we would.
There is an order.
Yes.
There is an order of this court. 2027 is the deadline.
So, my Lord, if your Lordship, my Lord, say the second was held, why these people did not come, my Lord? The second was held after 7 years, 2021, A part. B is, my Lord, if your Lordship sees, my Lord, your Lordship.
Everyone was looting the state.
Lord, that, my Lord, is that teachers,
so now let us hope for a better future.
We always have to, my Lord, look to a future, to a dawn, my Lord.
I can appreciate
only 2-3 things.
This happened almost 20 years ago. By then it was not in contemplation.
Only 2-3 things.
Neither the constitutional amendment or the enactment, neither of them was there, my Lord.
2-3 things, Lord. The word which was troubling your Lordship was, my Lord, if your Lordship sees, my Lord, your Lordship has seen, 23(1), my Lord. Your Lordship said, my Lord, any person, and you were not a teacher at that point of time. But if your Lordship sees, my Lord, the proviso, my Lord. The first proviso. So provided that a teacher, now the word person here, my Lord, should be read to mean a teacher. Provided that a teacher.
Sir, 23(1),
yes,
at the risk of repetition, we are saying 23(1) says,
yes, my Lord,
any person who wants to be a teacher must have the qualifications under 23(1).
Correct.
Any person who wants to be a teacher. And first proviso says a teacher. So that presupposes that you're already in service. So if you're in service, you are given 5 years time to upgrade yourself.
To give the
Millet, there were instances, if I may add, Millet, there were instances when relaxations were made.
Like a broken record, we have been repeating the same again.
There were instances when states represented to the central authority,
I will only
because we don't have the wherewithal, it should be exempted. Such categories which have been exempted from minimum qualification, they were given this opportunity, not the ones who had the qualification by word go.
Would it be 4 years, my Lord?
Why we didn't challenge it? There is a letter of 2017. The amendment of 2017. Now,
whose letter?
This is already there 6 months.
MHRD's letter, which reflects.
What is the date?
3rd of August 2017. The amendment came on 10th of August 2017. Now, this letter of MHRD.
3rd of August 2017. What did it say? Just tell us.
It laid down detailed guidelines to all states and union territories about gaining the qualification required and to meet the deadline. And the only thing it referred to and discussed in detail is getting a DLED, which is a diploma in elementary education. And this, your Lordship, the reason why this is important, I tell your Lordships, Regulation 5, your Lordship will again, I'm sorry to say, read Regulation 5 of NCT 2010 regulations. Regulation 5 very categorically says that Those regulations.
Can you please come to para 69 of our order?
Yes, Your Lordship.
Have we read 3rd August 2017 erroneously?
I'll tell you, Lordship, why.
You just tell us that.
Yes, Lord.
Just look into 69.
Yes.
Have we read the 3rd August 17 order erroneously?
No, but the question is,
We have said, Madam, just see 69.
what were the
Additional Secretary MHRD issued a letter to the state secretaries reminding that the last date to acquire minimum qualifications is 1st April 19, and no teacher who did not possess minimum qualifications under RTE would be permitted to continue in service beyond the given date. Is it a wrong interpretation of the letter?
No, Lordship did not interpret the letter. Your Lordship merely said minimum qualifications. But what are the minimum qualifications? The question. There are 22 steps which the 2017 letter talks about. Everything involves diploma in elementary education and online distance courses for diploma in elementary education. There is not a whisper about TET in that.
Very well.
And I'll tell you, Lordship, why their understanding is. That understanding is in consonance with Regulation 5 of 23rd of August 2010. The Lordship just read Regulation 5 once again. I know your Lordship has read it. It very categorically says, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointments may be made in accordance with NCT 2001 regulations. Under Section 23, the gold standard is NCTE. 23 does not say what your minimum standards are. 23 says NCT will lay down minimum standards. Rightly or wrongly, NCT 2010 has two categories. Those who are prior to the notification, those who are post-notification. Whether it is in one way or the other, that is a law. NCT 2010 is a law. It is in consonance both with 12A of NCT Act as well as RT. It is not contrary to either. NCT 2010 notification creates two categories. Those who are appointment prior to the notification date and post-notification date. Prior to 2010 notification date, they say the standards and qualification of 2001 will apply. Post 2010 notification, 2010 will apply. So all those who are selected prior to a selection process prior to 2010 are governed by NCT 2001. It does not mean there are no standards.
Very well. Thank you.
And that
Anyone else?
They form a different class when it comes to 2000 up to 2010 minutes.
My lord,
Form a different class.
My lord, I have appearing for Women Teachers Association.
2010 may be a justification.
Would the TET exams be held after every 6 months, my lord? Otherwise,
I am appearing for UP Women Teachers Association. UP Women Association, my lord, of teachers of UP, my lord. My lord, the only one, first of all, my lord, there should be a schedule in which, my lord, the states have to conduct these exams, my lord, so that all the backlog may be cleared, my lord. That is the first, my lord. And secondly, my lord.
In case they are not holding the exam within time, you are at liberty to approach the court. The problem is,
my lord, it doesn't happen, my lord. My lord, if it is a part of the order, my lord, they will listen to it, my lord. And then, my lord, lady members, my lord.
You find you were here right from the beginning.
Yes, my lord.
What did Tamil Nadu say?
Yes, my lord. They said 4 years, my lord. Then my lordship accepted.
No, because they say that if the teachers in position they don't qualify, we will be without
schools will be
teachers.
closed, my lord. Yes.
So whose duty it is to hold the TET under the law?
States, my lord. But they
states.
Yes, my lord.
Now, state on the one hand will say that don't require TET to be acquired by the teachers. On the other hand, they will say that we will be out of teachers.
Yes,
What is
my lord, lakhs of vacancies are there, my lord, in the schools, my lord. They are not.
There are lakhs and lakhs of individuals who have qualified TET and are waiting in the wings. Let them be examined. Let them be assessed.
Yes, my lord. I'm only praying, my lord, to give some exemptions to ladies, my lord.
Sorry?
Some exemption to ladies.
Ladies are in our judicial service more than 50%. And you want exemption for ladies?
My lord, now the situation is different.
Just see the judgment authored by Brother Manmohan in Arshnur Kaur.
You have said now their time has come and there will be reservation for men.
My lord is absolutely right, my lord, but reservation is now happening in Supreme Court also, my lord.
My lord, may I, my lord, only take 1 minute, my lord? My lord, only one.
Please allow us to reflect.
My lord, may I handle
What is
just
reserved
notification?
my lord,
only 1 point, my lord.
We will have to Work it
My lord,
out.
30
Whatever
seconds,
is
my lord.
discussed,
My lord, 30 seconds, my lord, only 1 point.
My lord, may I hand it over just two notification, nothing more, nothing less.
Very well, give the notification.
May I hand it over this?
We'll consider.
One is state conduct guideline and another one is
On the
extension.
Golden Forest matter.
My lord, only one line.
Your Lordship, just to
One thing, my lords, I wish to point out. Consider the
Lordship, I wish to
extension.
point out about
Extension.
Jammu and
Nothing more,
Kashmir.
nothing less.
May I make a limited submission only on the retrospective effect?
We will look into
Your
all the
Lordship.
questions, whatever points are there. Our notes are ready. We will
Your
look
Lordship,
into
Your Lordship, may I?
Lordship, very important
Lordship, may I
2
just
points
submit
which
one
is
thing?
already concluded in the entire matters, Lordship.
Your
One
Lordship-
first is there, give the Lordship the time to the teacher eligibility test for, and second is there, Lordship, very important. The attempt, Lordship.
Your Lordship.
Give the attempt to the more
Your
than
Lordship,
one to
may
more
I
than.
just submit about
What is
Jammu
that?
and Kashmir?
Very important. Physical education and the music teachers is not considered under the act of the TET examination. In this, Lordship,
Sharma ji, bulaiye bhai.
please,
my lord, only
one sentence, my lord. My lord, they are, my
lord, the teachers
are ready to.
Our appoint is prior to 2009. We are ready to give the TET test. Only we should be given promotional post also. And if we fail, my lord, we will lose the service as well as promotional post. That is only what our contention is there.
I seek permission to withdraw 301.4.
Forest.
I'm for the promoters.
No, first, today we will hear Mr. Fernandez, Madam, and Mr. Prasad.
Only last time, Lord, you all should issue notice in my application.
Wait for a minute. Yet all the DC and the
They are
I know, so that